Hello everybody, my name is Will Martin and I'm an attorney for the North Carolina Realtors, and I am delighted to have the opportunity to speak with you today for a few minutes about the subject of handling multiple offers, which is a very common source of questions on the legal hotline and a topic that I have spoken about quite a few times over the years. Of course, it's great for you to have interest in your listing from multiple buyers, but I know it can be stressful too. The parties' emotions are typically running high and things are happening fast. And you know there's some rules that you should be thinking about in handling the offers properly, not to mention a working understanding of what's required to form a contract for the sale of real property according to contract law. I could speak on this topic for several hours, honestly, but I've only got a few minutes today, and so my modest aim today is to briefly highlight what I think are a handful of relatively clear legal and ethical rules you need to have a good grasp of when you're involved in a multiple offer situation. If you keep these rules in mind and you keep your wits about you and you manage the expectations of your client, you should be just fine. I'm just going to focus on several rules that come into play in four aspects of handling multiple offers. Those are, one, disclosing the existence of offers on the property; two, disclosing the terms of offers on the property; three, presenting offers; and four, responding to offers. So let's get right to it. Topic number one, disclosing the existence of offers. The question is, does the real estate license law or the code of ethics require a listing agent to disclose the existence of offers on the property? First, let's think about the license law. There is not a specific rule on this, but the Real Estate Commission takes the position that the existence of an offer on a property is not a material fact that the listing agent must disclose to other interested buyers. On the other hand, the Commission does expect listing agents to treat competing buyers fairly, or to keep them on a so-called level playing field. So if you apply that to a multiple offer situation, for example, if there are two competing buyers and the listing agent discloses to buyer number one that there's an offer on the property, another offer on the property, the listing agent would be expected to disclose that fact to buyer number two as well. So what does the Code of Ethics have to say about disclosing the existence of an offer on the property? Unlike the license law, there is a standard of practice in the Code of Ethics that specifically addresses a listing agent's duty to disclose the existence of other offers. Standard of Practice 1-15 states, and I'm just going to quote from the code, "Realtors, in response to inquiries from buyers or cooperating brokers, shall, with the seller's approval, disclose the existence of offers on the property. Where disclosure is authorized, realtors shall also disclose, if asked, whether offers were obtained by the listing licensee, another licensee in the listing firm, or by a cooperating broker." If you break that down a bit, the first thing you should understand is that the disclosure obligations under Standard of Practice 1-15 arise only if the seller authorizes the disclosure of offers on the property. Stated a different way, if the seller has not authorized the disclosure of multiple offers on the property, that would be considered confidential information that you would be expected not to disclose. So to disclose or not to disclose is indeed a question you need to discuss with your seller client when a multiple offer situation presents itself. In fact, the first discussion of the subject ought to take place when you list the property. That's why you'll find the following two sentences straight out of the code set forth in the firm duties paragraph of the exclusive right to sell listing agreement. And I quote, "In accordance with the Realtor Code of Ethics, firm shall, with seller's approval, in response to inquiries from buyers or cooperating real estate firms, disclose the existence of offers on the property. Where seller authorizes disclosure, firm shall also disclose whether offers were obtained by the individual agent who signs this agreement, another agent of the firm, or by a cooperating real estate firm. That ought to sound familiar. So if the seller approves of the disclosures of offer on the property, and if a buyer or an agent working with a buyer asks whether there are other offers, Standard of Practice 1-15 requires you to disclose the existence of any other offers and whether the other offer or offers are in-house offers or from another agent outside your firm. Of course, even if a cooperating broker doesn't ask if there are any other offers on the property, you can and should disclose the existence of another offer if the seller has authorized disclosure and if you think it's in the seller's best interest under the circumstances to disclose the existence of the other offer or offers. On the other hand, if the seller does not approve the disclosure of other offers on the property, you should not disclose the existence of another offer to an interested buyer, even if you are asked. If the buyer agent asks if there are other offers on the property, you should simply say that the seller hasn't authorized you to disclose information about the existence or absence of other offers on the property. So far, I've been focusing on the duties of a listing agent, but what about the buyer agent? Does the Code of Ethics impose any ethical duty to ask if there are other offers? Not specifically, but buyer agents are legally and ethically obligated under both the license law and the Code of Ethics to act in their client's best interests. I can't think of any reason why a buyer agent who is presenting an offer shouldn't ask if there are any other offers. And so I think it's a good practice for buyer agents to ask whether there are other offers on the property when presenting an offer for their buyer. Okay, moving on to topic number 2, disclosing the terms of offers. The question here is, can a listing agent disclose the terms of an offer to a competing buyer? I won't spend much time on this topic because I think most everybody is aware that the answer to this question is a big fat no. Real Estate Commission Rule 58A.0115 clearly says, and I quote, "A broker shall not disclose the price or other material terms contained in a party's offer to purchase, sell, lease, rent, or to option real property to a competing buyer without the express authority of the offering party." So, listing agents, even if you think it's in your client's best interest to shop an offer, don't do it. That is, unless the buyer whose offer you want to shop says it's okay. And good luck getting permission from a buyer to shop their offer. Moving on to topic number 3, presenting offers. Both the license law and the Code of Ethics require you to present all offers and counteroffers quickly. Real Estate Commission Rule 58A.0106 requires delivery within 3 days. The Code of Ethics doesn't have a specific delivery for deadline, but Standard of Practice 1-6 of the Code requires realtors to deliver offers and counteroffers objectively and as quickly as possible. It is interesting to note that Standard of Practice 1-7 relieves a listing agent of the obligation to present offers after the property is under contract if the seller waives the obligation. However, there is no such exception in the license law, and the law always takes precedence if there is a conflict between the law and the Code of Ethics. So, listing agents, keep presenting any and all offers you may receive even after your client's property is under contract, and they may say, "I don't want to see any other offer." You're still obligated to do it. Applying the code and the license law to a multiple offer situation, listing agents should understand that they can't hold offers, at least not for very long, simply because they expect to receive other offers. Generally speaking, they should be presented to the seller as they are received. But just because a listing agent has a duty to present offers right away doesn't mean that the seller has any duty to consider them within any period of time or to consider them in the order in which they were received. One other thing I'd like to mention while we're on the topic of presenting offers. MLS rules permit an agent working with a buyer to participate in the presentation to the seller of the buyer's offer unless the seller instructs the listing agent in writing that the seller doesn't want the buyer agent to be present when the offer is presented. The potential benefit to a buyer asking to participate in the presentation of his or her client's offer seems obvious enough, but I think there may also be benefit to a listing agent actually requesting that a buyer agent be present in the presentation of the buyer's offer. In particular, when the buyer whose offer is being presented is represented by an agent with another firm and there's a competing buyer who is being represented by the listing agent or another agent in the listing agent's firm. I'll call them the outside buyer and the inside buyer. If the outside buyer loses out on the property to the inside buyer, I can tell you that the potential for a complaint by the outside buyer that they weren't treated fairly is very real. And it seems to me that giving the outside buyer's agent the opportunity to present the offer to the seller should help insulate the listing agent against a claim of unfair treatment. If the listing agent is representing the other buyer himself or herself, I also think it's a good idea for somebody other than the listing agent to handle the presentation of the offer to the seller, if that's possible. Okay, moving on to topic number 4, responding to offers. Let's say you've gotten 3 offers on your listing. You've done your job so far. You've disclosed or not disclosed to the competing buyers the fact that they are in a competitive situation, depending on the seller's instructions, and you've timely presented all 3 offers to the seller. What's next? The seller, of course, is in control of how they want to deal with the offers, and that is going to dictate to a great degree what you do next. The seller has a lot of options. The seller can accept one of the offers and reject the others without giving the other buyers an opportunity to submit another offer. The seller can reject all 3 offers. The seller can choose to neither accept nor reject any of the offers. The seller can negotiate with one of the 3 buyers but not the others. Those are just some of the options. There are probably some more. Neither the license law nor the code of ethics provides specific guidance on what a listing agent's duties are in responding to offers, whether it's a multiple offer situation or not. In preparing for this presentation, I reflected on that absence of specific guidance, and the more I thought about it, the more sense it made that there aren't and shouldn't be a lot of specific rules about what an agent can and can't do in responding to offers. That's because, as I just noted, there are so many ways in which a seller may choose to respond or not respond to an offer. And if there are multiple offers, the different options increase almost exponentially. It would be really hard to craft rules that would adequately address so many potentially different situations. But just because there aren't specific rules to guide you in responding to offers doesn't mean that you can do whatever you want. Remember that you have very fundamental legal and ethical duties to act in your client's best interests and at the same time treat all parties honestly and fairly. In the context of responding to multiple offers, how do you manage the competing interests of the seller and the competing buyers? That's a very abstract question, so let me give you just one concrete example to illustrate how you might balance the duty to act in your client's best interests on the one hand and treat the other party fairly on the other hand. The question comes from a 10-question true-false quiz on handling multiple offers that I wrote for the August 2018 issue of Insight magazine. I'm just going to read one of the questions, give you a second to think about it and answer true or false in your head, and then I'll give you the answer. The question is, assume 3 buyers have submitted offers on the same property. Question number 1 is a lowball offer, but offers 2 and 3 are within the realm of what the seller might consider accepting. Since it's the seller's prerogative to accept, reject, or ignore any offers, it is permissible for the listing agent in this situation to contact the agents representing buyers number 2 and 3 to request that their clients submit their best offers and not to respond to the agent for buyer number 1. True or false? Give you just a second to think about it. Okay, time's up. The answer to the question is false. Although the listing agent doesn't have to invite buyer number one to submit another offer, fairness dictates that the listing agent must at least contact buyer number one's agent to let him or her know that buyer number one's offer has been rejected by the seller. Of course, if buyer number one submits another offer, the listing agent must present it to the seller. In addition, if the listing agent discloses the existence of multiple offers to the agents for buyers number 2 and 3, the listing agent would also be obliged to disclose that fact to the agent for buyer number 1. If you're interested in the rest of the quiz, you can get a copy of it in the archived Q&As on the NC Realtors website at ncrealtors.org under Insight Articles. You can access the archived Q&As by clicking on the Q&A quick link after you log in. Well, that's all the time I have for today. Just a very quick summary. Remember, you have to disclose the existence of multiple offers on the property if your seller consents and if you are asked if there are other offers. If you disclose the existence of multiple offers to one competing buyer, you need to disclose it to all competing buyers. You can't disclose the material terms of an offer to a competing buyer without the consent of the offering party. You have to present all offers quickly and in no event more than 3 days. And you have to treat all buyers fairly in responding to their offers. Also remember, when you get into a multiple offer situation, try to remain calm, even if your client isn't. Apply the legal and ethical rules I've been talking about today, and always seek guidance from your broker in charge if you're presented with an unusual or complex situation. Also, don't hesitate to contact my partners and me on the legal hotline. John, Bill, and I can't give you specific legal advice on the hotline, but we will be delighted to talk through whatever your situation is and to give you our general thoughts. The phone number for the hotline is 336-294-1415, and the email address is legalhotline@ncrealtors.org. I can't see if I've got any questions. It looks like I don't really have any substantive questions yet, but if I do get any, I'll review them and I'll follow up with you. And as I said, if you want to call and ask about a particular situation, don't hesitate to call us on the hotline. Thank you for tuning in today. Take care and Happy New Year.